If a building is closed for the night and a group of people refuse to leave, the law calls that trespassing. But how much power does the state have to make you move? If you aren't fighting back, if you're just sitting there peacefully, can an officer use physical pain to force you to your feet? More importantly, if they do, does the law protect them from being sued? The Supreme Court just answered this in a case called Zorn v. Linton. It's a study of a legal blueprint called qualified immunity, and today we're going beyond the blocks to see where the line is drawn. In January 2015, a group of protesters staged a sit-in at the Vermont State House. When the building closed at 5 p.m., police officers informed everyone that they would be arrested for trespassing if they stayed. One of those protesters was Shela Linton. When Sergeant Jacob Zorn approached her, he didn't immediately use force. He asked her to stand up. He warned her that while he didn't want to use force, he would have to if she didn't cooperate. Linton refused to move, later stating that being forcibly removed was the goal of her protest. In response, Sergeant Zorn took her arm, placed it behind her back, applied pressure to her wrist, and lifted her to her feet. Linton later sued the officer, claiming the compliance hold caused her physical and psychological injury. This case centers on qualified immunity. Think of it as a legal shield that protects government officials from being sued personally unless they violate a clearly established right. To break that shield, a plaintiff has to prove that any reasonable officer would have known, based on previous court cases, that their specific actions were illegal. The lower court ruled for Linton. They argued that because she was nonviolent and posed no threat, the use of a painful wrist lock was excessive. But the Supreme Court took a different view of the blueprints. They asked, was there a specific rule already in place that told Sergeant Zorn he couldn't use that move in this exact situation? In a unanimous decision, the Supreme Court reversed the lower court and ruled in favor of the officer. The court's logic was that Sergeant Zorn followed the proper steps. He gave fair warning. He identified a lawful reason for the arrest. And he used a standard police technique to overcome Linton's passive resistance. The court found no clearly established law that prohibits a standard wrist lock under these circumstances. From a legal standpoint, if an officer gives you a warning and a chance to comply, the law grants them the discretion to use the force necessary to complete the arrest. This ruling reinforces how difficult it is to bypass qualified immunity for the court. It's about ensuring that officers can do their jobs without the constant fear of a lawsuit for every split-second decision, provided they follow the established rules. But it also raises a question about where passive resistance ends and excessive force begins. What do you think? Once a warning is given, should the shield protect the officer's choice of force? Or should nonviolent protesters be handled differently? Let's talk about it in the comments. Thanks for going beyond the blocks. I'll see you in the next one.